said we're going to talk about the different kinds of courts, and then we're going to get a little sidetracked. Well, here we go. We're going to talk about arbitration and mediation, because these are terms that are floated around all the time by a lot of people who have never been in either one. Let's start with mediation. Mediation is a non-binding meeting of the parties to try and resolve the case. Sometimes that's in front of a mediator. A mediator would be a third party who has no interest in the case, who's going to hear the people argue, present their case, present their position, and then make a decision. Now, when I say it's non-binding, I mean that they don't have to follow what a mediator suggests. Now, the parties might enter an agreement out of mediation that might be binding, but they don't have to complete the mediation. At any point, a party can leave mediation and walk out the door, right? It's an attempt to settle the case, but it's not binding. Now, there's a big difference between mediation and arbitration. Arbitration is binding before someone called an arbitrator. An arbitrator is essentially a private judge. Again, no interest in the case. No, they're not friends with one party or another party. But the arbitrator is somebody who's going to hear the case and decide the case based on the evidence, but is not a judge in a court. Now, a lot of dealers say all the time to me, hey, I've got an arbitration agreement. They need to go through arbitration. And I make clear oftentimes to be very careful about demanding arbitration. Number one, arbitration doesn't automatically happen. One of the parties has to request it. Number two, it can be very expensive for the dealer. Because think about it this way. Dealers don't have to pay for a judge. The county pays for the judge. However, an arbitrator is paid for mostly by the dealer. In consumer arbitration cases, where you have a consumer on the other side, the company is expected to pick up a lot of the bill. And so that can become very expensive. Now, the nice thing about arbitration is that you avoid a jury. And none of us really know at any given time what a jury is going to do in a case. So where a judge or an arbitrator might say, this is a $5,000 case, a jury might feel like the car dealer really did something very wrong and award $50,000. It's possible, right? And the only way to guarantee avoiding a jury is to enforce an arbitration clause, because there's no jury in arbitration. Now, remember I said before, you could have a bench trial in state or superior court before a judge, right? That can happen, and then you don't have a jury. But all it takes is for the plaintiff or the plaintiff's attorney to file a one-sentence request for a jury in order for the case to go to a jury. So that's why a lot of people have arbitration agreements and sometimes will use the arbitration agreement, because even though you got to pay the arbitrator, and even though it's more expensive, two things happen out of that. Number one, the case is handled much faster. And number two, there's no jury in the case. So that's arbitration. Mediation, non-binding before mediator. Arbitration, binding. Arbitration is a totally separate filing, separate case. Mediation can happen as part of litigation to try and settle a case, or it can happen even before litigation is even filed. Even before a lawsuit is filed, the parties can suggest, hey, why don't we go try and mediate this thing and see if we can come to a resolution before you even go down the expensive road of litigation.